Good evening, everybody. We welcome you to today's event being hosted by Global Citizens One Word Affair, where our aim and object is to create the legal awareness for the legal fraternity. And in this mission of ours, we have decided to conduct series of webinars wherein we are trying to do on some important issues of legal awareness for the legal fraternity. Hopefully everybody is able to hear me, the things, because since it is a comparatively a newer concept, but hopefully we'll be shortly with the momentum. So I once again welcome all the participants, all the viewers, especially the members of the legal fraternity who have both from the private side as well as from the prosecution side, the officers from the police department, the judicial officers sitting, as well as the training officers. And also I welcome on board the students, the faculty members, the research scholars, and everybody who has joined in from various parts of India, especially from North India and from various parts of globe also. A very warm welcome to everybody. In this enchanting 1 hour of enriching experience, we will try to today interact on a very interesting and intriguing topic, that is the Ndps practice and procedure, which indeed is itself a very, very interesting topic. The reason why we have chosen the speaker for today is that Mr. Baljinder Singh Sarah, who is the keynote speaker for the day, is not only a legal luminary in himself, but he is a perfect blend of being a practicing lawyer and also being on the judicial side as a judicial officer, firstly as a judicial officer's first class, then being selected to the superior judicial services, and right now working as faculty member in the Chandigarh Judicial Academy. So when I heard a word with our keynote speaker, Mr. Baljinder Singh Sarah, ADJ faculty member, Chandigarh Judicial Academy, I was so pleased and heartening that he said that, Saurav, you need not to worry. We will definitely have this session, not only this session, we will have much of these sessions where we can have substance, where we can have quality, where we can have wonderful interaction, which is really a source of knowledge for the legal fraternity. That's how we started with this mission. That's how we conceptualized this. And that's how we were able to come on this platform today. Mr. Baljinder Singh Sarah in himself is also, I will term him as a legal genius, because many of my friends and colleagues, they will term him as Khan of legal knowledge. So I always have a highest respect for him as an elder member of the legal fraternity, and also as Khan of legal knowledge, where he is called as an ocean of the legal knowledge, where he is always trying to help and contribute in his own manner and way towards the legal fraternity. A special word of thanks to all my team members who have motivated me to organize this event. A word of thanks to my elder brother Swapan Dheer also, who has been throughout helpful to me in the technological aspect of the events, and is co-host with me today. And a special word of thanks to the people who have joined from the various districts of Punjab and Haryana. because the procedural part which we will be discussing today and which the keynote speaker has prepared in the simplified manner, I think will be very, very enriching and very, very knowledgeable. So couple of things before I welcome and call upon our speaker. I would request everybody to be on the mute mode only, although we have formulated in such a model. Towards the end of the webinar, we will be definitely giving you an opportunity where you can have an interaction or you can ask your questions. But for that also, we would request you to put your questions on the chat box, which is there on the downside. अगर आप नीचे देखेंगे एक चैट बॉक्स आपको विजिबल होगा, आप उस चैट बॉक्स में अपने क्वेश्चंस एंड क्वेरीज पुट इन कर सकते हैं, जिसको डेफिनेटली हमारे जो कीनोट स्पीकर हैं ये वुड डेफिनेटली बी टेकिंग देम वन बाय वन एंड सीइंग द अवेलेबिलिटी ऑफ टाइम. बट जिस तरह से ये एनडीपीएस का ज्ञान रखते हैं या जिस तरह से इनको एनडीपीएस की नॉलेज है, I will share my personal experience being on the state side when I represent the government of Punjab. I had a lot of queries in my mind when I was on the state side, and I had to face the big lawyers like my elder brother, Mr. Jindal is here, and many other lawyers who are here. I would say Mr. Gupta, Mr. Garg, and Mr. Dhuriwala is also here. So when I had to face them, I definitely had an inceptive problem on certain issues, and the key force behind my motivation would always be Mr. Baljinder Singh Sarah, who is always and always a very big source of motivation and a big inspiration to the legal fraternity. With these words, I welcome all of you, and I welcome the keynote speaker for the day, Mr. Baljinder Singh Sarah, who will be taking us through this enriching journey of NDPS Act practice and procedure in today's evening today. Welcome, Shri Baljinder Singh Sarah ji.
Thank you, Saurav. Thank you so much. Am I audible to everybody?
Yeah.
Am I audible?
Yes, yes. Yes, you are audible.
Okay, thank you so much.
Yes, indeed, you are audible, sir.
Thanks, Saurav, for the nice and wonderful introduction. I thank you very much. First of all, I welcome all the participants who are here on this webinar today, which is on a very important topic, which is probably utilized by all the lawyers, by the judges, and by the students also. First of all, I would like to thank Global Citizen One World Affair, the forum which has been organized by Mr. Saurabh Khurana, which has given us the platform for creating legal awareness for the legal fraternity on various topics. It's indeed a step, right step rather, in the legal education, which Mr. Saurabh Khurana has taken all the pains in this troubled times for all of us to share our views, to interact on various topics in this time. So I thanks him once again for giving me this opportunity to be here with all of you. Today topic, the NDPS Act procedure and practice. I'll be dealing with this topic in six segments. In the first segment, I shall be dealing with the preliminary part of the NDPS Act. In the second segment, I shall be giving the overview of the probatory and regulatory mechanism provided in the Act. In the third segment, I shall be dealing with the offenses and penalties provided under the Act. And the fourth segment will be presumption and reverse burden clauses, which are very important under the Act. And then cognizance and bail. And then last part would be the procedural and practice part, which shall be dealing in the last. So I shall be playing one PPT also for the benefit of all the participants. Just give me a minute. I would like to share the PPT. Now, so far as the NDPS Act is concerned, is the PPT visible?
Yes, yes.
Mr. Khurana?
Yes, yes, Mr. Shah.
Okay, thank you so much. Now, as the name of the act suggests, this act deals with the narcotic drugs and psychotropic substances. Now, if we go into the legislative history of the act, prior to this act, we had three pieces of legislation. That is the Opium Act 1857, Opium Act 1878, and the Dangerous Drugs Act 1930. But these were found wanting and were not in tune with the international legal framework, which led to the enactment of the Act of 1985. Now, so far as the international and constitutional framework is concerned, which is behind the enactment of the Act of 1985, we have three important international conventions. Now, why I want to draw your attention to these three conventions is that our entire act, especially the definition part, is structured on this international framework. In this, we have the Single Convention of Narcotic Drugs, 1961, and amended by the 72 Protocol. Then we have the Convention on Psychotropic Substances, 71. And then we have the United Nations Convention Against Illicit Traffic in Narcotic Drugs and Psychotropic Substances Act 1988. Now, why these conventions are important? You will notice that in the act, in the definitional part, we have two terms which are clear from the title of the act itself, that is narcotic drugs and psychotropic substances. Now, the literal meaning of these two words is entirely different from what the meaning has been assigned to these terms under the act. Now, if we say narcotics, the literal meaning of narcotics, which has been taken from the Greek word, means any substance which will induce sleep or relieve us from pain. But under the Ndps Act, this is not the meaning which has been assigned to this narcotics. Its meaning has been taken entirely from the Single Convention of 1961, and all those substances which were covered under this Single Convention of 1961, they were put or lumped together under the umbrella of narcotic drugs. Let me remind you that the word drugs here doesn't mean the meaning which is assigned to the word drug under the Drugs and Cosmetic Act. It's a generalized word. Similarly, if we see the classification under the act broadly divides the substances into three categories. One is narcotic drugs, second is psychotropic substances, and third is controlled substances. This is the broad classification which is given under the act. Now, Section 3 of the act empowers the central government to add or omit from the list of psychotropic substances by way of any official notification. The latest example we have is the addition of tramadol into this list of psychotropic substances. Now, similarly, if we go to the meaning of psychotropic substances, now the term psychotropic is composed of two words, psychosis and tropic. Psychosis refers to the mental disorder or personality disorder, and tropic refers to the geographical region which falls between Tropic of Cancer and Tropic of Capricorn, which is also known as torrid zone. So the literal meaning of psychotropic substances is those substances which naturally grow in this geographical area and which have the propensity to affect the central nervous system of the human beings. Example are cannabis plant, coca plant. But again, the meaning assigned to psychotropic substances under the act is again different from the literal meaning which this word carries. Now, so far as the act is concerned, I've already stated the classification is not based upon its literal meaning or the effect of the substances on human body or their geographical origin. The act defies this strict compartmentalization, and the definitions have been by and large body lifted from the international conventions. So as and when we have any doubt or any issue of interpretation or construction regarding the meaning of any word or any term which is employed in the act, then we should refer to the international convention to clarify the meaning of those terms or words. Then the third category is controlled substances. Now, controlled substances was added later on to the Act. Now, these may be narcotics, these may be psychotropic substances, or these may not be anything. But generally, these substances are employed to derive other products or substances from the naturally occurring narcotics or psychotropic substances. These are to be notified by the central government. One example is like acetic anhydride is such chemical which is used in the manufacture of heroin. So it may have multiple uses, therefore such substances are controlled by the Act. Now, before I take up some of the definitions under the Act, I shall not be able to take up all the definitions, but I shall be referring to a few definitions which would be relevant for us to understand the meaning of certain terms used in the Act. I would like to share with you certain principles which shall be handy in interpretation of the definitional clause under the Act. Now, the meaning of the words I've already stated have been taken from the international conventions. Then the United Nations Office on Drugs and Crime, they have published one dictionary, that is Multilingual Dictionary of Narcotic Drugs and Psychotropic Substances under international control. This also defines certain terms which have been used in the Act. Now, let us take a few examples. Now, let us take the definition of cannabis plant. Now, this definition of cannabis plant has been body lifted from the Single Convention of 1961. Under the Act, it has been defined to mean any plant of genus cannabis. Now, so far as cannabis is concerned, again, it means church, ganja, or any mixture with or without neutral material of any of the above forms of cannabis or any drink prepared therefrom. Now, there is one word which comes in this definition, that is neutral material. This word is not defined in the Act anywhere. So the question arises before us that what is the meaning of this neutral material in this definition? Why this word was used? Now, this basically refers to, because when we talk of this neutral material, this you will find in the a few other definitions like opium poppy and all that. So basically, these are the substances which we get from the plant or vegetative source. So a plant will obviously have different parts: roots, stem, leaves, fruits, and it is possible that each part may not have the substance which is controlled or regulated by the Act. Some part of the plant may be without any of the narcotic or psychotropic substances or its properties. So therefore, neutral material refer to the other parts of the plant which may get mixed up while harvesting such kind of crops. Now, I'll just like to share with you regarding the bhang. If we see the definition of ganja in the Act, you'll find that it excludes seeds and leaves of the plant. So the seeds and leaves of the plant, cannabis plant, they though contain the psychoactive ingredient, but this is in very negligible form, and that's why bhang has been excluded from the ambit of the definition of this cannabis, and thus is outside the ambit of the Act of 1985. But it definitely comes within the Excise Act because it still contains intoxicating properties. So bhang doesn't fall within the ambit of the Ndps Act. Then similarly, we have the definition of this opium poppy, which is the plant, and it is the source of remaining two substances, that is opium and poppy husk or poppy straw. Again, you will find in this definition under the Act, it uses the term neutral material. Again, this word neutral material refers to the other part of the plants which may not contain the narcotic substance. So therefore, at the time of harvesting of such plants, it is but general that the other part of the plant will also get mixed up with the part of the plants which yield the narcotic or psychotropic substances. So the neutral material referred to that part of the plant. Now, I'll share with you the definition of word preparation also, because this word carries a very distinct meaning under the Act, and it has been you can see also the matter of interpretation and confrontation also in the courts while deciding upon the issue in the relation to narcotic drugs and psychotropic substances, that whether in cases of mixture or preparations, the non-narcotic or neutral substance is to be counted or reckoned while computing the commercial or the small quantity under the Act. Now, preparation, if we see under the Act, it has been defined to mean one or more such drugs or substance, either in dosage form or any solution or mixture or in whatever physical state. Now, physical state, we all understand the matter can exist in three states conventionally, that is solid, liquid, or gaseous state, containing one or more such drugs or substances. Now, the definition of preparation itself clarifies that in case of mixture, in case of solution, in case of this dosage form, it is going to be mixed with other substances which may not be either narcotic or psychotropic substances. So therefore, whenever a question comes that it is a case of preparation, in that case, the whole of the quantity of the preparation or the mixture is to be computed towards the narcotic drug or psychotropic substances. Now then we have the definition of commercial and small quantity. Here the only point which is relevant for us is that the any quantity greater than the quantity specified or any quantity lesser than the quantity specified has to be given its literal meaning, and therefore whatever is specified in the notification, it is to be construed accordingly. That suppose if the quantity is given 5 gram in the schedule under the head of small quantity, so any quantity less than this specified should be taken as small quantity. And accordingly for commercial also, if the upper threshold limit is, let us say 200 grams, so beyond 200 grams it will be commercial quantity. Now let us take the definition of psychotropic substance. Now under the Act, you will notice that it includes any natural substance or any synthetic substance or any natural substance or material or any salt of such substance or material or any preparation of such substance or material. Now there is much wider definition of psychotropic substance, but you will find that this word natural substance, natural material, these are not defined in the Act. So question before us would be that what are the meaning assigned to these words? From where do we get the meaning of these words? Now for this I'll just again we have to refer to the international convention also. But if we analyze the definition, it distinguishes the psychotropic substances on the basis of being natural or synthetic. Natural means which exist in the nature in its free state, like plant-based or maybe in any other shape. Synthetic means which are synthesized in a clinically or laboratory. Now the term natural material basically refers to the plant which constitute the psychotropic substance, and the natural psychotropic substance refers to the actual substance which we shall extract or obtain from the plant source. We have two examples, like psilocybin. It is a psychotropic substance which you will find in the schedule also under the Act. It's a natural occurring psychedelic compound which is found in 200 species of mushrooms. So therefore, this substance though psychotropic substance is also available in its natural state in the nature. And this psilocybin can also be synthesized in a laboratory. It can be prepared artificially also. This is the main reason that in the definition of psychotropic substance, they have employed all these terms: natural material, natural substance, just to ward off any mischief which may come by the accused, saying that since he is carrying something which exists in the state of nature and he has not produced or manufactured anything on his own, substances, and referring to certain words used in the psychotropic substances definition. Now I'll just share with you one case also, which is an English case, which is visible on the slide also. In this case, the person was found in possession of certain substances, that is cannabinol derivatives, which were part of the cannabis plant itself in its natural state. Though this case is under the Misuse of Drugs Act 1968 under the English law, the court held that if the person is found in possession of some natural material, that is the plant itself, containing any of the psychotropic or the narcotic substance, then he would not be guilty of the offense under the act. So in order to ward off such kind of a defense, in the definition of psychotropic substances, the legislature has employed all these words just to negate the potential mischief which may arise in such kind of situations. As I also shared with you the case of psilocybin. Now this case also arose before the Canadian courts also. And in the Canadian courts, initially, there were two courts of appeals which, taking the cue from the English case, they held that possession of the natural material, that is psilocybin, that is the mushroom, will not amount to any offense under its Drug Controls Act. But later on, the Supreme Court of Canada had to undo the mischief, and it reversed all those decisions and held that the possession of psilocybin mushroom in its free form would also fall within the mischief of the act. So that's why we have the word natural material, natural substances in the definition of psychotropic substances. Then there had been a controversy also regarding the psychotropic substances. There were two controversies. One controversy was that whether because we have a list of psychotropic substances in the schedule, and then the rules also, it also contain a list of psychotropic substances for its regulation. Now the controversy was that if a psychotropic substance falls in the schedule of the rules, but do not find mention in the schedule of the act, or vice versa, whether it would fall within the mischief of the act or not. Now this controversy was resolved by this Sanjeev Deshpande case, holding that if the psychotropic substance is in the schedule of the act, irrespective of the fact whether it finds mention in the rules or not, it shall be covered within the ambit of the act. Then the second controversy was regarding the pure drug content or the entire mixture, which is to be reckoned for computing the small or commercial quantity. Now, in the beginning also, I have already referred to the definition of preparation. But this entire controversy otherwise was misconceived. And the reason why the court missed the keywords in the act and instead relied upon its literal interpretation resulted into this entire controversy. So had they referred to the word preparation, which ultimately the Supreme Court has referred in the case, in Hira Singh case, the controversy would not have arisen. So in case of mixture or solution or preparation, it is but natural, we have already referred to the definition, that apart from the pure narcotic drug or psychotropic substance, it will be mixed up with the other material. So that may be for many reasons. We have already referred to the neutral substances and other things. So therefore, the Supreme Court now has, on the interpretation of the word preparation, has held that the entire mixture or preparation is to be computed towards the reckoning of the commercial or small quantity. Now, next one of the important definitions I would like to share or discuss with you is manufactured drug. Now, in the trial courts, you will mostly find that there is we can say confusion regarding the framing of charge under section 21 and 22. 21 deals with the manufactured drug and 22 deals with psychotropic substance. Now, generally, the people understand that the term manufactured drug or confuse it with drug manufactured by some licensed or unlicensed pharmaceutical unit. So this is not the meaning of manufactured drug under the Act. It has got a specific meaning. It includes both categories of substances having narcotics and psychotropic properties. It includes natural substances. It includes derivatives of the natural substances. It also includes the artificially or clinically produced substances also, which are to be notified by the central government. So there are three notification in the last clause, clause B of the definition. One is of 85, wherein 88 drugs have been mentioned. And then we have the notification of 93, notifying 17 drugs under the category of manufactured drugs. And then we have the notification of 2011, mentioning 5 drugs under this category. Now the second part, this was the first segment. I referred to a few definitions. The second segment pertains to the prohibitory and regulatory mechanism under the Act. Now I'll just make quick 2 points on this. One is that section 8 and 8A of the Act deals with the prohibitory mechanism under the Act. It prohibits various activities, operations act in relation to these 3 categories of substances. And the remaining sections, that is section 9 onwards, that deals with the regulatory mechanism. That is of allowing these activities by way of a permit, authorization, or a license. So these are the principal provisions, and the remaining provisions under the Act, they supplement or complement these provisions.
Sir, can I request you to please mute your phone because the bell is ringing, you know.
Okay, sure.
I'm sorry to say that, but there's a lot of voice which is coming in between. Sorry, sir.
I'm sorry for that.
Yeah.
Now, if we see or read section 8 of the Act, it prohibits the following activities or operation. That is cultivation, production, manufacture, possession, sell, purchase, transport, warehouse, use, consume, import interstate, export interstate, import into India, export from India, transship. Now, some of these words have been defined in the Act, while others words are not defined. So, but I will not be referring to, I will not be able to define all of these operations or activities, but I'll just refer to few, like the word sell. It is not defined, but it simply means transfer a thing for a price paid or promised. Purchase, it means buying something. Transport is defined in the Act. It means conveying from one place to another place, but here it carries a specific meaning. That is transport or conveying these things within the state or the union territory. Then cultivation is not defined, but it means if somebody is bestowed labor and attention on the plant so as to promote its growth. So the wild growth of plant will not come within the mischief of the Act. Manufacture is defined. It includes, it excludes production, which basically deals with agricultural operations under the Act, and manufacture deals with other operations like refining, preparation, propagation, compounding, processing. Then to import interstate means within the state, import into India. Then use is also defined. It means any use except personal consumption. consumption is not defined, it is relevant in section 27 of the Act. Then to export from India, export interstate, transship means to shipment of goods or container at an intermediate destination for further onward transmission. I would like to discuss in detail the word possession, because most of the cases which come before us, either in the courts or otherwise, fall under this category. Now the concept, this word is not defined in the Act. Now the concept of possession has definitely raised peculiar difficulties in its application in criminal law. We say it is an elusive concept and it's changed colors and shapes in different circumstances. But there are two key elements of the possession, that is animus and corpus, which must exist to form this concept. So it could be actual, constructive, symbolic, exclusive, or joint. Section 27 IPC is relevant in this context, which says that a possession of a person's wife, clerk, or servant on account of that person is considered to be the possession of that person and not that of the wife, clerk, or servant. Now, what is the rule or the principle where there is a house search? Now, the general rule is that one who is in exclusive possession of a place is considered to be in conscious possession of all the articles found in that place, unless it is rebutted by that person. But where there are many occupants of the house, then this presumption is not applicable, and it depends upon the facts and circumstances of the case, whether the occupant or all the occupants jointly possess an article in that place or not. Then we have the case of joint Hindu family. So in case of any recovery effected from the house or the property of a joint Hindu family, whether the karta would be held liable for possessing that, or the other members along with him would be held liable, or is there any presumption in favor of the prosecution which is to be reverted by the accused? Now, there are three principles which have been carved out by the courts. One is that there is no presumption that the karta or the head of the family who is in possession of the house would be presumed to have control over anything found in the house. The circumstantial evidence has to be led by the prosecution to attribute possession, conscious possession on the part of either the head of the family or jointly with the other members or some other members individually. Then possession could be exclusive also, or it could be joint or collective. But in any case, it has to be proved that it is a joint enterprise of the two persons or more than two persons to attribute joint possession on their part. For example, if two accused jointly transport contraband in a car or carry about their person, even though one is physically holding the contraband, both would be taken to be in joint possession. Then we have the case of recovery from a vehicle where it is occupied by more than one person. Now here also the courts have laid down the test of a joint enterprise, which has to be proved by the circumstantial evidence, by the prosecution, in order to attribute joint possession on the part of all the occupants of the vehicle. Now, these are three propositions which I have called out, that possession means conscious possession. Prosecution has to prove direct concern or physical custody of the contraband, and the burden of proof then is upon the accused to prove it otherwise. Now, next important part is offences and penalties under the Act. Now, while discussing this part, I would like to share with you two questions which would arise in this context. First one is whether the offences under the Act are absolute in nature. That is, whether they impose strict penal liability excluding the element of mens rea, or the element of mens rea is required under the Act. You will notice that except for the 4 provisions under the Act, that is section 19, 25, 26 and 38, none of the charging section under the Act mention mens rea as an essential element to bring home the offense. Even if you read section 15, 16, 17, you will not come across the word either intentionally, or knowledge, with knowledge, any of the act like possession, transport, sell, consume, produce, manufacture. You will not find the element of mens rea having been used in the charging section under the Act. Now the question would be, in the absence of any specific provision in the Act, can the element of mens rea be read in all these activities, operations, and the offenses? Now, the general principle under the penal law is that in order to constitute an offense under the common law, both the elements must exist. That is the actus reus as well as the mens rea in order to constitute the offense. But there are exceptions to this general penal principle. Now, question is, where the enactment is silent, it becomes a matter of construction that whether the element of mens rea should be read into it or it should be excluded. Now, so far as this Act is concerned, this Act does not create strict liability offenses. In each of the activities or acts mentioned in the Act, that is whether possession, cultivation, transport, etc., the accompanying mens rea has to be read as an integral part of the offense. Now, next question is whether this mens rea has to be proved by the prosecution. The answer is that this has been taken care of section 35 of the Act, which supplies the element of mens rea by raising a legal presumption in favor of the prosecution and throwing the burden upon the accused to disprove it beyond reasonable doubt. Now, once the actus reus is proved beyond reasonable doubt by the prosecution, the mens rea part is supplied by the presumption engrafted in section 35 of the Act. Once these two elements coexist, then the court may raise the presumption from the factum of possession that the accused has committed the offense by virtue of section 54 of the Act and throws the burden upon the accused to prove the contrary. And the burden thrown upon the accused is of the heavier nature. He cannot simply get away by raising a reasonable doubt in the case of the prosecution. He has to prove this on the standard of preponderance of probability. I'll refer to these parts later on when we come to presumption part. Let us take few illustrations to demonstrate the element of mens rea in the Act. Now, A has an agricultural land and grows wheat on the same. Few plants of cannabis grew on its own on the other end or the side of the field without his knowledge. Now, he cannot be said to have cultivated, that is knowingly cultivated the cannabis plant on his land. So he will not be guilty of any offense. Let us take another illustration. A is employed as a driver in a transport company and works in shifts. He takes a loaded truck from the company with all the requisite documents, which indicates that it contains bags of rice. On the way, his truck is intercepted and bags are found to contain contraband. Now, he cannot be said to be consciously transporting or possessing the contraband because the element of mens rea would be missing in all these situations. We can take another illustration of a courier boy who is going to deliver the parcel to somebody at some address. And as per the rules of the company, he is not required to open the parcel to find out its content. He is intercepted and the parcel contains heroin. He cannot be said to be either in conscious possession of the contraband or transporting the same. Now, next important aspect on this offenses part is whether the general exception under the IPC will be extended to the Ndps offenses, or in other words, if I simply say that if the a child of 6 years of age is found in possession of a contraband, can he be prosecuted under the Act even as a juvenile? Now, for this, we refer to Section 40 of the Indian Penal Code. It states that for the purposes of the chapter of general exception, that is chapter 4 of IPC, the word offense means an offense under the IPC or under any special or local law. Section 41 of IPC defines special law, means law applicable to a particular subject. Now, Ndps Act is a special act governing offenses of specific category. So therefore, it follows that general exception in the IPC would be applicable to all the Ndps offenses. Now we take few illustrations. Let us take the case of a child of 6 years. He is found in possession of 20 grams of opium, and Section 82 IPC stipulates that nothing is an offense which is done by a child under 7 years of age. So he will not be guilty of any offense. He will not be prosecuted even as a juvenile under the this Ndps Act. Now let us take the second case. A person of unsound mind is handed over a packet of contraband by somebody, and this person is arrested, and the unsoundness of mind is of such a nature which is covered by Section 84 of the IPC. Again, he would not be guilty of any offense. So from here you can make out that all the general exceptions, whichever are applicable to the Ndps Act, would be applied. Now, next important aspect is, again, this is in the part of general exception, that whether the ignorance or mistake as to the quality or kind of substance would be a defense under the Ndps Act. Suppose a person goes to somebody, let us say a RMP doctor in a village, and asks for some medicine for some ailment. He is supplied some loose tablets, and later on that person is arrested with those tablets, and those tablets are found to contain either narcotic or psychotropic substances. Now, question is, can he plead that there was a mistake or ignorance on his part regarding the kind of substance which he was carrying? The answer again is yes. We have few English cases on the point, which you can see in the on the slide also, that in two situations he can plead this defense if he's completely mistaken as to the nature of the contents of the container, or he doesn't suspect that there is anything wrong with those contents. So in this, he can plead this defense. There is one Canadian case also of 57, Beaver versus Ragaman. Here the man asks for a harmless remedy but was given by mistake a package containing a prohibitive substance. The Canadian Supreme Court held that mere custody or control was not sufficient, and if the accused honestly believed the contents of the package to be innocent, then he would be acquitted of the charge. Now, next important aspect is reverse burden clauses. Here we have three different provisions, that is 35, 54, 66. Now, this is one of the most confusing part, where you will find a mesh of cases of the Supreme Court also, taking different and contradictory position, using you can say different phrases to define the ambit of these provisions. Now, I have already stated that the general principle of penal law is that in order to constitute the offense, we require two elements, that is actus reus and mens rea. And it is for the prosecution to prove both the elements beyond reasonable doubt. Now, but this general principle can be displaced by the legislature by enacting different provisions which under the law are known as reverse burden clauses. They may take different shapes. Now, it could be possible that, like under the Ndps Act, the mens rea element is supplied by Section 35 by carving out the presumption in favor of the prosecution and throwing the reverse burden upon the accused to disprove it by the standard of beyond reasonable doubt. Now, if we read it holistically, both the provision, that is 35 and 54, now we can come, it brings a few principles out of this. One is that initially it is on the prosecution to prove the physical control of the contraband beyond reasonable doubt on the part of the accused. Once they reaches this threshold or crosses this threshold, then the second part would be mens rea part, which will be supplied by section 35, which carves out an you can say presumption in favor of the prosecution. Once this is done, the permissive presumption under 54 may be you can say the court may fall back upon this presumption and come to the finding that accused has committed the offense and throws the reverse burden upon him to prove it that he is not guilty of the offense under the act. Now there is one phrase in section 54, unless and until the contrary is proved, and the second phrase is satisfactorily account for. Now these two phrases, which have been interpreted by the courts also, this cast a bit higher standard of proof on the accused. The accused cannot get away from the offense by simply raising reasonable doubts in the case of the prosecution. He has to prove it by the standard of preponderance of probability. So it imposes a higher threshold limit upon the accused than what is available in normal situations. Now, next aspect which comes from this reading of these two reverse burden clauses is that what is the clear-cut criteria or the parameters available with the courts to find out that the prosecution has covered the first threshold limit of proving the actus reus on the part of the accused. If we survey the case law of the Supreme Court and the High Court on the subject, you will find that it does not indicate any clear-cut criteria for this. Rather, they increases the confusion by using contradictory phrases in their judgments. Now, the correct approach is, or what the courts have done is, now if the foundational fact, that is actus reus or the factum of possession, which is required to be proved by the prosecution beyond reasonable doubt. Now, in Ndps cases, what happens? The prosecution says that he was found in possession of the contraband, which they prove by showing the search, seizure, and all these kind of formalities, which they effect at the spot. Now we have a procedural prescriptions from section 41 to 50, or let us say 57 of the Act, which tells the prosecution or the investigating or enforcement authorities how to effect the search, seizure, and all such kind of things. Now, what the courts have done is, the courts have divided all these procedural prescription into two broad categories: mandatory procedural prescriptions and directory one. In case of violation or infraction of the mandatory procedural prescription, then the evidence collected in violation of that has to be eschewed from consideration. It is not taken into consideration. While in case of directory one, the whole gamut of facts is to be seen, whether it affects the case of prosecution and how much does it affect. Now, next part I would like to discuss with you is I was referring to the Supreme Court judgments on this point. We can just have a look on this, that there is a lack of coherent approach by the courts in interpreting section 35 and 54 of the Ndps Act. Now, the first case is Noor Aga case, where the constitutional validity of these reverse burden clauses was upheld by the apex court, but it was clearly stated that procedural requirement laid down in the Act has to be strictly complied with. Now, relying on Noor Aga case, in Mohanlal case, the Supreme Court used the expression that prosecution is required to prove or establish a prima facie case beyond reasonable doubt. after investigation. Now this phrase doesn't make any sense. Prima facie case itself implies a case which is established on the preliminary assessment of the material available on the record, and beyond reasonable doubt is something different, that there should not be any doubt on whatever material the prosecution is relying upon, whereas this phrase was not used in Noor Agha case. Then in Hanif Khan case, the Supreme Court again used a different phrase. It said that prosecution is required to establish a prima facie case only. Again, a contradictory phrase. Then in Dharampal case, again, a different phrase is used. It says it creates legal fiction. Again, this is a wrong term. A legal fiction is different from presumption. A presumption only places the or shifts the burden of proof from one person to the other person. Whereas legal fiction, the other person is not entitled to rebut it by any means once the fact is presumed by way of a legal fiction. Whereas reading of 35 and 54 indicates that it only reverses the burden of proof from the prosecution upon the accused on satisfaction of certain foundational facts. The next important part is cognizance and bail under the Act. Now, reading of the provision of the Act indicates that exclusive jurisdiction is vested with the special court in respect of offences punishable with more than 3-year imprisonment, and the remaining offences are triable by Judicial Magistrate first class by virtue of Part 2 of Schedule 1 of CRPC. The power to grant initial remand vests with the regular magistracy, which is also required to perform the acts stipulated in Section 52A of the Act at the initial stage itself. But after the initial remand, the magistrate is required to forward the accused to the special court if the case is triable by the special court. And thereafter, the special court shall deal with the remand of the accused and other related matters. Now, after the accused is transmitted to the special courts, it may exercise same powers which a magistrate having jurisdiction can exercise in respect of 167 CRPC, remand, cognizance, presentation of police report, etc. Now, special court is a court of original jurisdiction, and there is no need of commitment of the case to the special court by the magistrate. Now, next comes the concept of default bail. Now, so far as default bail is concerned, the provisions have been modified by the provisions of the Ndps Act. The time period beyond which the default bail annuites to the accused in CRPC has been extended to 180 days. And there is a further provision for extension up to 1 year on satisfaction of certain conditions. This enlarged period is applicable in respect of offences under Section 19, 24, 27A and offences involving commercial quantity. Then what are the conditions which are required to be satisfied for extension of time period? First is there should be a report of the public prosecutor. Second, the report should indicate the progress of the investigation. Third, the detention, it should specify the compelling reasons or circumstances for seeking the detention of the accused beyond the period of 180 days. A notice should be issued to the accused. Now, though this is notice part is not there in the Act itself, but it has been introduced by judicial precedent. Now, the provision does not indicate or enumerate specific reasons on which this could be, the time period could be extended, but from the reading of the provision, it is clear that there should be a rational nexus with the completion of the investigation. It should not be a ruse or an excuse or inaction or lethargy on the part of the investigating agency. Now, while preparing a report, the public prosecutor is required to independently apply his mind to the request of the investigating agency before submitting his report to the court for extension of time, and he is not to merely act as a post office. The request of the IO for extension of time is not a substitute for the report of the public prosecutor. So merely writing on the application of the investigating agency forwarded or requested, that is not suffice. The report should indicate clearly that the prosecutor has independently applied the mind, weighed the reasons given by the IO for seeking extension of time, and then he should make the report to the court. Otherwise, this report is no report in the eyes of law. Then the rigors of 37(1)(b), that is the additional conditions, these are not attracted to the default bail. Now, next important part is the concept of incomplete challan or incomplete police report, that whether default bail is to be granted in such situations or not. Now, you'll find case law on either side. But before we consider this aspect, let us see what is the purpose of filing the police report. Now, we have to consider two factors in this context. One is the nature of the missing material and its relative importance for making out the alleged offense against the accused. Second is whether the material already collected by the IO brings out a prima facie case in respect of the alleged offense so that the court may proceed with the case. Now, the whole purpose of filing the police report with the court is that court is able to take cognizance of the offense and proceed further. Now, if the material collected prima facie discloses the ingredients of a given offense, then the absence of the missing material does not have any bearing upon the filing of the police report, which may be incomplete. Now, insofar as IPC offenses is concerned, the rule is clear and loud that satisfaction of requirement of 173(2) CRPC is sufficient, and absence of any material, even the sanction also under the Corruption Act, is not fatal or is not considered material for saying that the challan is complete or incomplete. But in NDPS cases, the situation is a bit different. Here, the possession of the contraband is an offense. And unless there is some material on the record to indicate the nature of the substance or material allegedly recovered from the accused, it would not be possible to form a prima facie view whether any offense is prima facie made out or not made out. So, despite all the different case law on either side, I have drawn three conclusions on this aspect. The first conclusion is the absence of chemical examiner report should not have any bearing on the filing of police report in the two situations. That is where the contraband can be deciphered by physical test or examination, like the case of poppy, husk or straw. If on physical examination, a person who is able to give the opinion, like the IO who is engaged in this work for a long time, and since these are the plant-based material, and if we can decipher by physical test, then absence of chemical examiner report should not be the ground to extend the default bail. Secondly, in cases where the contraband has been tested at the spot by using spot testing kit, again there is a preliminary or modicum of material on the record to indicate the nature of material recovered from the accused, and the court can at least frame the charge in that situation. The report of the chemical examiner would be a corroborative in nature, which can be even filed subsequently. But in all those cases where there is nothing to indicate the nature of the substance recovered from the accused, the benefit of default bail should be extended to the accused, because the concept of default bail balances the two fundamental, you can say, concepts. One is the concept of liberty enshrined in Article 21, coupled with the right to fair trial, which includes speedy investigation, speedy trial, and the need of the investigating agency to collect the relevant material. Now, next important part is whether all the offenses under the Act are non-bailable in nature, or whether the offences which are punishable up to 3 years are bailable in nature, or offences with small quantity, whether those would be taken to be bailable or non-bailable. Now, if we see section 37, which is the relevant section, you'll find its heading is a bit misleading. It says offences to be cognizable and non-bailable. But I would like to draw your attention or share with you, originally in 1985, when this act was enacted, original section 37 was like this, that is offences to be cognizable. So there was no mentioning of whether the offences are bailable or non-bailable under the act. And therefore, it was governed by the CRPC, which offense would be bailable or which would be non-bailable. Then this 37 was substituted in 1989. And in 1989, what they added was, again, the heading offences to be cognizable and non-bailable. But in the body of the act, the enactment, there was no mention that whether all the offences would be non-bailable under the act or not. Only additional conditions were imposed in certain offences, and remaining part was silent. So this 37 was again amended in 2001 and slightly tinkered with. And therefore, the conclusion which comes from the reading of these provision is that offences which are punishable up to 3 years shall be taken to be bailable in nature. There are certain judgments also which have taken this view. Then there is second limb of section 37, that is imposition of the additional conditions, that is notice to the public prosecutor, hearing him before grant of bail, and then additional 2 conditions, that he is not guilty of the offence and no probability, reasonable probability of his committing the offence again. Now I'll just briefly share with you a few points on this. Now, first question is whether anticipatory bail is maintainable in these offences which are covered by 37(1)(b). Answer is yes. Anticipatory bail is maintainable, but the additional conditions mentioned in 37(1)(b) would be applicable even in that situation also. These conditions would also be applicable at the time of granting suspension of sentence under 389 CRPC. It is wrongly depicted as 498, it should be 389 CRPC. Now, this is the last part of the lecture, which deals with procedural prescriptions. Now, if we analyze the provisions from section 41 to 57 of the Act, we'll find that the Act divides this procedural prescription into 2 categories: pre-recovery and post-recovery. In pre-recovery, we have 41 to 50. And post-recovery, we have 52 onwards. Now, in pre-recovery procedural prescriptions, there is 3-fold classification under the Act. First classification is on the basis of warrants or authorization. That is, whether this arrest, search, seizure can be effected with warrants or authorization. And second is when it can be effected without warrants or authorization. The second classification is on the basis of place. That is, whether the search and seizure is to be effected in a building, conveyance, or in closed place, or it is to be effected in a public place or in transit. Then third classification is on the basis of personal search and search of articles under section 50. So I'll briefly refer to this. So far as the first classification is concerned, warrants and authorization, it empowers judicial magistracy and gazetted officer of certain department under section 41 to issue the warrants and authorizations. Now, because of the time constraint, I would like to skip this differential part between 41 clause 1 and 41 clause 2. we can take the difference between section 41 and 42. This would be relevant for us. Now in 41, you have seen that it empowers the judicial magistracy and the gazetted rank officers of certain department to issue the warrants or the authorizations. Whereas 42 deals with warrantless or without authorization search and seizure, and it empowers the officers above the rank of peon, sepoy or constable of various department to perform certain functions under this provision. The second is the judicial magistracy or the gazetted rank officer under 41 can order arrest, search, seizure by day or night on the satisfaction of the conditions stated therein. Whereas in 42, there is further bifurcation between the search or seizure to be effected during the daytime and during the night time. The empowered officer under 42 can do the needful between sunrise and sunset, and he can act in the night time only in emergency situations when he has reasons to believe that a search warrant or authorization cannot be obtained without affording an opportunity for the concealment of evidence or escape of the offender. And in this case, he has to record his grounds of his belief and within 72 hours send the copy of this to his immediate official superior. Then reason to believe doesn't mean a pretense or subjective satisfaction. It should be based upon certain material and should be reached in good faith. I'll skip this part, that is 42, I've already discussed with you. Now, the only part which we need to refer to here is that all these provisions provide certain procedural prescriptions which are required to be satisfied by the investigating officer at the time of acting under these provisions. Now, in 41, you have seen the power is with the magistracy or the gazetted rank officer. So therefore, it prescribes a less threshold of procedural prescription. In 42, the power is being exercised by the empowered officers. Now here, it is hedged with certain further procedural prescriptions which he has to comply with, like if he has reason to believe from his personal knowledge or on the basis of secret information. In that case, he has to record this information in writing, dispatch the copy of this information within 72 hours to his immediate official superior. Now, another aspect is that if the search is being effected under 42 by the gazetted officer, then whether he is required to comply with the procedural formalities stipulated therein, the answer is no. If he himself is acting or heading the search party, then there is no need to comply with section 42. The next bifurcation is that whether search and seizure is to be effected in a private place or a public place. Now here the Act makes a distinction between building, conveyance, enclosed place, which they have put in one category in section 41 and 42, and public place and conveyance in transit in section 43, that is in the second category. Now, I would like to share with you that so far as building and enclosed place is concerned, it is clear that these are the places which are within the private domain of the individual. And this procedural prescription or bifurcation flows from Article 21 of the Constitution of India, that is to protect the privacy of the individuals, that there should not be unnecessary intrusions or interference with the privacy of the individual. And therefore, the Act provides certain safeguards whenever a search is to be effected in some building, enclosed place, conveyance. Now, why this word conveyance is used along with the building or enclosed place? Now, the reason or rationale for this again is the international convention. You all are aware of this fact that in many foreign countries, there is a concept of van dwelling. The number of people they live in a vehicle which they have modified in the shape of a house. So therefore, the word building, conveyance, and enclosed place are to be read together. But public place and conveyance in transit in a public place is to be separately seen. Now, meaning of public place, the explanation to the provision states that it includes, so it is not exhaustive, it is inclusive. It means public conveyance, hotel, shop, other place intended for use by or accessible to the public. The ownership or possession of the place is not material. What is material is that whether the place is to be used or meant for use by the general public. Similarly, hotel and shop is not a public, it is a public place, but a room in a hotel has been held to be a private place. So far as conveyance is concerned, I have already stated that in order to come within the ambit of this act under section 41 and 42, it should be a private conveyance, it should be meant for residence, it should be stationary. Then let us see the correlation between section 42 and 43. Now, question before us is whether 43 and 42 are totally exclusive or are they interdependent? So there has been a lot of controversy among the courts on this, but now the matter stand resolved that when there is a search and seizure under section 43, that is in a public place or a conveyance in transit, then there is no need to comply with the procedural formalities of section 42. So all those things would not be required to be complied with. Though you will find certain case law where even a private conveyance in a public place, the courts have held that 42 requirements must be complied with, but probably all those judgments are not correct. And this has been held also by the court in certain cases. Then in case of chance recovery, there is no need for any procedural compliance of these procedural formalities. Now let us come to the important topic of personal search. Now here also, this is the third classification. Here the act draws a distinction between the search of the person of the human being and of the other articles. It has got twofold objective. One is to protect the person against false accusation and frivolous charges. And second is to lend credibility to the search and seizure effected by the empowered officer. Now this section 50 interposes the intervention of magistracy or gazetted officer for effecting personal search. Now I'll just share with you a couple of points on this. Even if the gazetted officer is effecting search under section 50, even then he has to comply with section 50. Now this provision was diluted by the Amendment Act of 2001 by adding subclause 5 and 6, where it says that in emergency situations, the authorized officer may dispense with this requirement and himself effect the search by following the CRPC provisions. Then meaning of personal search, it means not only the body, but also include covering, clothing, footwear. One test of inextricable connection was laid down in this Namdi Francis case. It has been explained also. Now we can take few illustration that if the contraband is recovered from the pocket of the pants, it's tied to the waistband, hidden in the shoes, contained in the fist, hidden in the shirt, tucked in the pants, or put up in a plaster on his arm or leg. So in all these cases, section 50 would be applicable and it would amount to the search of a person. But where it is contained in some other article like sack, bag, handbag, sitting on the bag, in the car, so in all these cases, section 50 would not be attracted. Now there had been a controversy among the courts that where at the spot recovery is effected from the bag or some other article and personal search is also effected of the accused at the spot, and there is no compliance of section 50 while effecting the search of personal search, will it affect the search of the contraband affected from the article also? Now, the first case, Dilip and another versus State of Madhya Pradesh, this came from this case. This was the first case in which the Supreme Court had said that in this situation, it will also affect the evidence gathered by the effecting of recovery from the article. So that is that if there is non-compliance of Section 50 while effecting personal search, this would have a bearing on the recovery effected from the article being carried by the person. Now, this was again stated in Shah Alam case, then Permanent case, then recently in S.K. Raju case also, by relying upon the dicta laid down in Dilip case. But this has been now explained in Baljinder Singh case by the Supreme Court by relying upon Constitutional Bench judgment of Baldev Singh case, saying that the observation by the Supreme Court in these cases were only a vital and are against the rational or ratio laid down by the Supreme Court in Baldev Singh case. So this would not be applicable henceforth. Now, next would be that whether the offer should be individual or joint. So here it is simple that it has to be individual. It should not be joint. It may be in oral or writing, but it has to be proved by leading cogent evidence. It should be apprised to the accused or the suspect in clear and unequivocal terms. What language is to be employed will depend upon the facts and circumstances, but it has to be the language which the accused can understand. If he doesn't speak or understand the language in which the memos have been prepared by the IO, and there is no indication in the police diary or the case diary that it was explained to him by engaging the interpreter, in that case also there will be the non-compliance of Section 50. A consent memo is not will not be a sufficient satisfaction of Section 50. Then last part is the effect of non-compliance of these provisions. Now here I have already stated that the courts have divided these prescription into two categories. One is mandatory and other is directory one. So the violation of mandatory one would entail that the evidence collected in violation of those provisions would not be taken into consideration. Whereas in case of directory one, it has to be seen in the context of overall circumstances of the case and the appreciation of the testimony of the witnesses, and if it causes prejudice to the accused or it reflects upon the genuineness of the case of the prosecution, in that case, even those could be fatal. This probably can informant the investigating officer, the matter stand referred to the larger bench. Then we have the link evidence. If there is link evidence missing at any stage, this could also be fatal to the case of the prosecution. But what is a link evidence? Basically, it deals with the maintaining of integrity of the case property from the point of time of its recovery at the spot till it is produced in the court during the trial or is otherwise disposed of under the orders of the court, or till the sample safely reaches the chemical examiner. So detail I will not be probably discussing. I've already overdrawn on my time. Now probably we can be open up for the question answer session.
Sir,
Saurabh?
thank you so much, sir, for this. Yes, can you hear me?
Yes, yes. Can we open up for the question answer session?
Yeah, surely. So I would request everybody, if you have some questions or queries, you can post them in the chat box, because we would be taking your questions from the chat box, and accordingly, I'll be putting that question to the keynote speaker to address. And if there is some clarity more required, we will surely unmute you. But for the timing, we would take the questions in the chat box. But being in the meantime, we start having the questions, sir. It was such a wonderful and enlightening session. that I have no words to explain. It is almost 90 minutes of this non-stop journey that we have wonderful interaction and wonderful enriching experience on this subject. And meanwhile, we have a question, sir, from Rajiv Chaudhary. He says, how to calculate the quantity of opium plants?
All right. I would like to share probably one chart also with you on this. So far as the opium plant is concerned, in case of opium plant, the quantity is not either in the schedule or otherwise. If you see the offenses part, whether this chart is visible, Saurabh, whether the chart is visible?
No, you have to share the screen, sir. Now.
Yes, sir, please share it. Yes, visible? Now it is visible, sir. Please go ahead. Yes, sir. No, sir.
Okay.
Share the screen, the relevant part. Yes, sir. Now it's visible.
Now it is visible.
Yes.
Yes,
all
sir.
right.
It is visible.
Now, so far as the plants or vegetative these products are concerned, be it a cannabis hemp, be it a coca leaf, be it a poppy plant. So these are the cultivation or the gathering of these plants are punishable as such. There is no question of quantity or otherwise in such cases. Now I'll just try to draw your attention to this chart. You will notice that narcotic drug is a generic term which includes so many things. It includes coca leaf, cannabis hemp plant, which include charas, ganja mixture, opium, poppy straw, manufactured drugs, and manufactured drugs include further coca derivatives, medicinal cannabis, opium derivatives, poppy straw, and any other specified. Then you will notice that so far as plants are concerned, here at the bottom, cannabis plant is punishable under section 20. Coca plant is punishable under section 16. Opium poppy plant is punishable under section 18. In these three provisions, there is no question of employing the commercial or the small quantity. These are punishable as such. So is this clear, Saurabh?
Yes, sir. Yes, sir. It's clear. It's absolutely clear, sir. Thank you so much. Sir, we have another question from an iPad user. Although I would suggest everybody from the next session, we will be taking up with names, because sometimes, we cannot have who is the person who is asking. But anyways, so we have an iPad user, sir. He says he's Advocate Jay, and he wants to ask on the concept of strict liability is different from IPC under the NDPS. What is the difference of concept of strict liability in the NDPS and IPC, sir?
Yes. Saurabh, in case of strict liability, the element of mens rea is displaced. Otherwise, under the common law crimes as well as under the IPC, in order to constitute an offense, both the elements are required. That is the actus reus plus the mens rea, that is the blameworthy mind. Now, in strict penal offenses like under the Motor Vehicle Act, we have Drugs Cosmetic Act, where the element of mens rea is displaced by the legislature. Now, the similar proposition also cropped up here under the NDPS Act, because from section 15 onwards, which deals with offenses, I have already stated that the element of mens rea is missing. This provision does not use intentionally or knowingly possessing, intentionally or knowingly transporting, intentionally or knowingly cultivating any of these, you can say, narcotic drugs or psychotropic substances. So in the absence of any specific element in the enactment, the Supreme Court has interpreted that the Act does not impose strict penal liability. the element of mens rea is read into all these activities and provisions, even though section 35 of the Act, it infuses the element of mens rea or presumption in favor of the prosecution and reverses the burden of proof upon the accused. So the offences are not strict offences under the Act. Mens rea would be required in all these situations.
Thank you, sir. This was Mr. Jay's question. Hopefully it's clear to him. Next question is from Mr. S.S. Bawa. He says, which is the best theoretical book on this subject? So we were going to share this, that I would take a permission from Saransar that Saransar is coming up.
So I would not be saying that best book, though probably I have
Saransar is coming with the book, sir. Can you please
short book on this area
can you
of law.
Please share that on the screen, sir, if you have some
I don't have the I don't have the cover page
okay,
in this
anyway, sir,
computer.
No worries. We will have a soft launch of that someday on the web or on the physical platform as and when the lockdown opens up. So the next question, Bawa sir, we would definitely in person suggest you some good books from Mr.
But I'll definitely
I'll
share it. Saurabh, I would like to share one thing with the participants. In the beginning of the session, I had already shared with all of you that the Act draws heavily from the international conventions. So whenever you find any difficulty in interpreting the definitional part specifically, do refer to the international conventions from where the definitions have been taken, and probably they will not face much difficulty in that. Otherwise, the generalized book which you find in the market, I have not come across any book which has specifically referred to these international conventions, and they have sort of you can say pell-mell way of giving judgments which are contradictory in nature. But if you stick to the provisions of the Act, the structure of the Act, and the international convention, then probably you will not go haywire even if you have contradictory judgments of the Supreme Court or different other courts on a given point.
Surely, sir, surely. So can we switch on to the next one?
Yes, sure.
We have Shashvi Mehra. Probably she's doing the research on NDPS, and she wants to ask, sir, that Vidhi Legal Policy in Delhi came out with a report that they found that section 39 and 64 were surpassed by the judges. They collected this data through RTIS. Instead of sending the convicts to rehab, they were being sent to jail. So probably, Swapan sir, can we do one thing? Can we have Shashvi on the screen, I think, and unmute her to probably ask her, because the question is a little longer, so she can be...
So probably, you know, I can, Saurabh, I can share with you on this point that one of the criticism of the Act by the critics is that this Act is turning the addicts into convicts. The Act doesn't have any proper policy or provisions for rehabilitation of the addicts. So if we punish the addicts, the punishment is not going to serve any purpose. And if we go through the provision, like she mentioned, section 64, which is of interest to all of us, which deals with power to tender immunity from prosecution. Now, if you go through the provision of the Act, it is not being utilized in the courts. Probably I have not come across any case where this provision was being utilized, and wherever the accused made the application under 64, he was met with resistance by the courts. Now, there are two difficulties in invoking section 64. One is the interpretation of the section. It says that the accused has to admit his guilt before he can be granted immunity from prosecution. And second part is the going through the de-addiction treatment part. So therefore, once, and third part is that there are no rules framed by either the central or the state government, which should give the leverage to the investigating agency at the very point of the arrest of the accused by testing him from the medical board that if he is found to be addict, then immediately this beneficial provision should be extended to them. Instead of prosecuting them, bringing them to jail, putting them in jail for some time, and then asking them to move an application, admitting their guilt, and carry the stigma with them. So probably these provision does require clarifications at the hands of the courts.
Thank you, sir. Thank you. We have another question because we have users and participants who have joined in right from Jammu to New Delhi. So we have Mr. Sandeep Sharma, advocate from Amritsar, who is asking whether the recovery of 5 grams of heroin is bailable or not.
Yes, it is bailable. I've already said that any offense which is punishable up to 3 years under the Act is bailable. Now, bailable only means that once the search and seizure is effected at the spot, thereafter the accused should be bailed out by the investigating officer himself, and there is no need to take him into custody or bring him to the magistrate, or even if when he brings him to the magistrate should grant him bail at the very spot if it is a clear case. It is a clear case that it pertains to small quantity.
Thank you, sir. Thank you very much. Hopefully, Mr. Sandeep Sharma, your query is clear. Next, we have another query, sir, from Hardeep Singh Lodhi. He is asking that in case of borderline quantity recoveries, whether one can take benefit of container weight for the purpose of bail and sentence?
Yes. If the weight by the IO includes the weight of the container, and it is a borderline case, then the marginal concession has to be given to the accused in sentencing also, and at the time of grant of bail also.
Thank you, sir. So the benefit has to go to the accused as a common law principle says so, as much as I know. Next, we have another query, sir, from an HP user. He says that person arrested in narcotic drugs and then in police remand again in disclosure statement, then whether section 50 or 42 is attracted.
If he is
arrested in narcotic drugs and then in police remand again, then whether section 50 will apply or 42 will apply.
Probably the question is not clear. If,
so if the personal
search, if the personal search is to be effected, of the accused by the empowered officer under 42, in that case he has to comply with section 50. But probably if his question is to the effect that suppose under section 41 the magistrate has issued the arrest warrant of an accused and he is brought before the magistrate, and then in the presence of the magistrate his personal search is to be effected, then obviously 50 is complied with, otherwise also.
Thank you, sir. Thank you so much. And we have, sir, another question from Dheeraj Mahajan. He asks, he's a practicing advocate in the Punjab and Haryana High Court. He asks, sir, that can you please guide as to what is the effective remedy under the Ndps if the police has wrongly shown the arrest from some different place and time, and during the pendency of the petition before the High Court, seeking the transfer of the investigation to the CBI, meanwhile presented the challan. So he's asking this query on this aspect, sir, that if he's arrested from shown arrested from a different place.
Probably. Now, so far as this part is concerned, it is obviously a question of fact, which would require to be proved at the time of the trial. But so far as the change of investigation is concerned, on these grounds, the constitutional courts, High Court and the Supreme Court has power to transfer the investigation even after the filing of the challan. So therefore, there would not be any difficulty in seeking the same if they are able to show that the investigating agency was acting mala fide and are not acting honestly.
Thank you, sir. Thank you so much. Sir, we have another question from Priyanshu Kamra, who is also a practicing advocate, sir. Sir, I'm audible to you, please.
Yes, 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 please.
Sir, we have another query from Priyanshu Kamra, advocate. He asks, sir, when the whole mixture, including the neutral substance, is taken in for calculating the recovery, doesn't it create exaggerated offense for an accused?
Now we have to understand the rationale and the object of enacting the NDPS Act. Now, so far as the mixture, so far as the preparation of these substances are concerned, now in the beginning I have, while referring to section 8 and 8A of the Act, I have already stated that the Act is of a prohibitory nature. These substances, if somebody wants to possess it, requires a license, authorization, or a permit from the competent authority. Now, if a person is having a mixture, which is no doubt covered within the ambit of the Act, he is intentionally or knowingly carrying or possessing such a mixture. So in that case, the question is not that whether it will exaggerate the offense or it will enhance the offense so far as the accused is concerned, because you will notice that prior to 2001, when the concept of commercial and small quantity was introduced in order to rationalize the sentence structure, prior to this, there was no such bifurcation under the Act between the commercial quantity or the small quantity. So possession of any quantity of these substances was met with the same kind of punishment. So therefore, it was relaxed only with a view to save the addicts or the, you can say, the persons who are peddling small quantity of such substances and saving them from getting higher sentences. So therefore, it doesn't amount to enhancement of the offense, because the offense is created by the Act, and whatever the offense is, it is.
Sir, thank you, sir. We have the questions are pouring in, although we are already in the second hour of the session. Kapil, he says that use ganja right in remand, ganja fool. What can we do in such situations? This is a question from Mr. Kapil, sir.
Sorry, Saurav, I was not able to get you. Can you repeat the question?
Saurav, are you getting me?
Yes,
Sir,
yes,
Mr.
yes.
Kapil has raised. Yeah, I can. He says that sometimes the police, the recovery is of ganja fool, although it is ganja patti, but it is recovery of ganja fool. In that eventuality, what should be done, sir?
Am I audible?
Yes, yes, sir, you are probably.
All right. Now, so far as again, this will take us to the definition part, of the ganja. I would like to refer to the same. Just give me a minute. Now, ganja, which is defined in clause 2B, is the flowering of fruiting tops of the cannabis plant, excluding the seeds and leaves. So therefore, if this includes the flowering of the fruiting tops, then definitely it is covered within the ambit of cannabis hemp and would be punishable. The only part which is excluded from the ambit of this is the seeds and the leaves, which are not accompanied by the fruiting tops. So therefore, if it includes the flowering of the fruiting tops, it would be punishable. And Saurav, I would like to probably clarify one. There was query earlier regarding 5 grams of heroin. Now, I've already stated,
sir,
while referring to the commercial and small quantity, that the lesser than that is to be taken into account. So in case of 5 grams, it is not small quantity, it goes beyond that. That is intermediate quantity. And therefore, it would not amount to a bailable offense. So therefore, you have to see whether it is a small quantity or a commercial quantity. The only part which is excluded from the ambit of this is the seeds and the leaves, which are not accompanied by the fruiting tops. So therefore, if it includes the flowering of the fruiting tops, it would be punishable. And Saurabh, I would like to probably clarify one. There was query earlier regarding 5 grams of heroin. Now, I've already stated while referring to the commercial and small quantity that the lesser than that is to be taken into account. So in case of 5 grams, it is not small quantity, it goes beyond that. That is intermediate quantity. And therefore, it would not amount to a bailable offense. So therefore, you have to see whether it is a small quantity or a commercial quantity.
Thank you, sir.
Good evening, sir.
Good evening, please.
Sir, my question is, if a person is arrested once in narcotics case, then
Right.
again, please, in his disclosure statement, he refers that something is lying in my house. Whether then
Please.
again section 42 and 50's offer is available or not for him, sir?
There is no offer under 41 or 42. In that case, there is no need to comply with 50 because 50,
All right.
there is no need to comply because under 41, 42, there is no offer. There are only procedural formalities to be complied with by the investigating officer. So probably in that case, in case of disclosure statement, when he is going to effect the search of the house, there is no need to comply with the procedural formalities stated in 41 or 42. 50 would be applicable only in case of personal search.
Just one question has come now for Kiran Kumar, who is also a lawyer in the High Court only. He says if the IO conducted search of the accused and took out an envelope from the pocket and then gives offer to the accused, if he wants to get search of the envelope conducted from the visited or gazetted officer, whether provision of section 50 are complied with or not.
50 are not complied with in that case. And the evidence collected in violation of this would not be admissible. It is a case of non-compliance of 50.
Already are running through a very long session. It's almost 2 hours. So we should give the benefit of this to Mr. Sarah also. But in the meantime, we have, I can see the participants, as I earlier told, coming from all across the India, starting from Jammu and Kashmir to New Delhi to various lawyers from various district headquarters. And the way Mr. Sarah has taken us through this lecture has been a very, very memorable and interesting one. We will definitely keep on having such kind of sessions in the future also on various important topics. And the way Mr. Sarah was sharing about the recovery from the wagon reminds me of summer in some beautiful place of US or Europe where people would be traveling, but due to the unfortunate circumstances which are prevailing now, we are unable to move out. But such kind of wonderful knowledge which is being disseminated from various platforms, including the one we are running, makes us wonderfully connected to each other and makes us to utilize the time in the best possible manner. We have these kinds of sessions in the coming days also, and I would shortly have Mr. Sarah coming back to us, probably because of the electricity failure. He had to take a drink break, and I've already circulated and shared my number because we are coming up with 2 important sessions. One, we will be coming on the weekend, which will be focusing on the national and international opportunities for the new entrants and also for the people who are joining the legal profession. And especially we have invited the speakers from US and Canada, and from national law schools also a couple of people, and the vice chancellors probably from the national law school will be coming. Then I have also requested Mr. Sarah to come up on the Prevention of Corruption Act and its various important amendments, since that is also a very hot and a very interesting topic. So probably as and when we get the time slot available from him, we will have him with us. And I think Mr. Sarah will join us, but there are a couple of questions which we were not able to take. We will definitely put them to you on your mobiles and reach out to you. In the meantime, I'll request our former Joint Secretary, Madam Parminder Kaur Channa. She is there with us to please. I have really appreciated your dedication, sir, that you have sacrificed your tea time, you have sacrificed your drinks time, and now you're sacrificing, although I know you're a teetotaler, and now you're ready to sacrifice your dinner time for disseminating such wonderful knowledge from this platform, sir. And I would formally request Madam Parminder Kaur Channa, our former Joint Secretary, to please come up for a formal vote of thanks before we conclude this session. And before that, as I earlier told, we are coming up with a session on Saturday, and then we are coming up for a session on Prevention of Corruption Act in the next week, as and when the time availability is there. I've already circulated my numbers. You can remain connected. Madam, please come up for a formal vote of thanks, please.
Thank you, sir. A very good evening to all the respected dignitaries and all my colleagues. It is my privilege to propose the vote of thanks for this esteemed firm. It was indeed a highly informative and a wonderful session. I extend our sincere thanks to Honorable Mr. Baljinder Singh sir for sharing his valuable time for us and for sharing his intellectual views in today's session on the subject of various practices on the aspects of Ndps Act. Once again, I, on behalf of the Global Citizens Firm and on behalf of our convener, Saurabh Khurana sir, I would like to thank you, Honorable Shah sir, for delivering this informative lecture. It was indeed our pleasure and honor to have you today with us. I would also like to thank all the participants who have joined us today in this session. Thank you so much. Thank you.
Thank you, Parminder. Thank you so much.
Thank you, Parminder. Thank you. And thank you all the participants who have spared their time and who are being here with us in such testing time of COVID. But as they say, this phase shall also pass. With these words, God bless you all. Good one, good night, stay blessed. Shabba khair. Thank you. God bless.